When a person is placed on probation or community supervision, there are certain conditions given them. It's a laundry list of conditions, starting with condition number 1, which is basically don't break the law, don't pick up any new charges. Condition number 2, 3, 4, 5, they involve reporting to probation monthly, staying drug-free and alcohol-free, paying your monies, doing your community service. All of these things apply. If any of those conditions are violated in the duration of probation, a violation report is generated, which is literally just a heads up from probation to the DA's office that says, hey, district attorney, this person's violated their probation by violating this condition number or numbers, if it's multiple violations. The DA will then sign off on it, present it to the court and say, Judge, we would like a warrant to issue for this person because they have violated probation. The judge will review it and say, yes, let's issue a warrant and let's have a hearing on it or let's discuss it. And an MTR is now generated. Many times, motions to revoke probation are remanded without bond. The judge says, I want to hear from somebody, and it has to be an attorney about what's going on with this case before I consider setting a bond. Some judges in this county will not set a bond, period. Other judges pre-set a bond and say, you know what, I just want the person to bond out and I want to have them come to court and let's talk about what these violations are. Our firm, from the inception, gets a copy of the violation report, meets with you and begins to decide or determine a strategy on how we're going to approach these violations, because many times there's explanations for them. Just because a person tests positive for alcohol doesn't mean it's true. Just because a person is alleged to have picked up a new case doesn't make it true. The burden of proof that the state uses on motions to revoke probation is a different burden than in finding a person guilty beyond a reasonable doubt. It is by a standard known as preponderance of the evidence. They don't need much proof to prove that the violation is true versus guilty. Violations of probation are not proven by a guilt-innocent standard, but by a true or not true standard. So our firm will begin in looking at defenses for each and every allegation, getting a bond set and getting you positioned to either continue on probation as a first option or terminating the probation, which is sometimes possible to do at that violation hearing. Okay, our goal is never to see that you go to jail, but we're here to help. Please call us.